Secretary of the Press Club, and it's my pleasure today to introduce our speaker. But first, I need to remind you to silence your cell phones and that only members of the Press Club and members of the media can ask our speaker questions. Our speaker today is Judge John Michael Guidry, who today is a judge on the Louisiana Court of Appeal First Circuit, but after tomorrow's election, he will become the newest Louisiana Supreme Court justice, following the disqualification of his two opponents. Judge Guidry will be the Supreme Court's 7th justice and the 2nd black justice in a newly redrawn majority black district. Judge Guidry was first elected to the Court of Appeal in 1997 and re-elected in 2010 and 2020. He formerly served as a legislative assistant to the Honorable Joseph A. Delpit. He also served as the assistant clerk of the Louisiana House of Representatives and an assistant parish attorney. Judge Guidry was elected to the Louisiana House of Representatives in 1991 and to the State Senate in 1993. He was elected to a second term in 2002 while teaching at the Southern University Law Center. Judge Guidry is a 1983 graduate of LSU and a 1987 cum laude graduate of the Southern University Law Center. Please welcome Judge Guidry.
Let me say that it is a privilege and a high honor to be here with the Press Club. And let me first of all thank you as members of the press for your service. It is in the environment in which we live has become a much more unappreciated and sometimes volatile and sometimes dangerous job to do. But in order for us to maintain our democracy, we need a free press, and we need people who are committed to that. And so for that, again, I thank you for your service. Tomorrow, it is my prayer and hope that millions of Americans who have not already done so will exercise a hard fought for right to vote. It is a privilege that goes deep into the great wells of democracy that were dug by our founding fathers in the Declaration and in the Constitution. It is a right for which people have been beaten, have had dogs and hoses turned on them, have been imprisoned, and some have given their very lives so that individuals can exercise this most sacred right. And if our democracy is to endure, it takes the active participation of our citizenry. In addition to the right to vote, we need a free and independent judiciary in order to maintain our democracy. A judiciary that's committed to the rule of law, where nobody's above the law and nobody's beneath the law. A judiciary that's unbought and unbossed, who will decide cases without fear or favor, who will set aside personal biases and prejudices in order to reach the right conclusions. Unlike the political parts of our government, unlike the legislature and the executive, who have the power of the purse, who have the power to command troops, to make appointments, and to do all these things that the political branches are allowed to do, we as members of the judiciary derive our legitimacy from the fact that people trust us. And the only way that we're going to maintain that trust is that we continue to realize that our job is simply to apply the law as written, to interpret the law, to do so in a way that people can have confidence in the outcomes they receive from our judiciary. Justice Thurgood Marshall put it this way: the political branches of the government, they have the sword, but the judiciary has the robe. And if we ever seek to alter our positions, if we ever seek to become political and to seek to have policy outcomes that we desire, to have certain results in cases, then we lose that legitimacy. And people won't feel that they can come to the judiciary in order to peacefully resolve their contentious issues. And one of the ways in which we can build upon that trust is to have a more diverse judiciary, so that individuals, when they walk into the courtroom, they will see individuals that are representative of the rich diversity of our state. They will feel more trustworthy in a system where they know that their lives, situations, and the perspectives and the ideals that they have are shared by those who are making the decisions on their very lives. And so it is that on January 1st, I will take the oath as the newest justice of the Louisiana Supreme Court. I will only be the fourth African-American justice in the 211-year history of the Louisiana Supreme Court. It is a point that has come through demonstration, that has come through litigation, and that has been a result of legislation. It is a fight that has been ongoing. It is a fight that, again, began with demonstrations. It began with demonstrations that were part of the Civil Rights Movement that led to the Voting Rights Act of 1965. And it is that basis, the Voting Rights Act of 1965, that was the underpinning of a federal lawsuit that was filed in the United States District Court for the Middle District of Louisiana. It was a lawsuit that was filed by the Lawyers Committee on Civil Rights with Arthur Thomas, a local attorney who had been a part of other civil rights lawsuits serving as a local counsel, and with lead plaintiffs like Michael McClanahan, who is the president of the Louisiana Conference of the NAACP, and other courageous plaintiffs who went to the court and simply said that if Louisiana has a third of its citizenry being African American, then on a 7-member Supreme Court, the math should suggest that there be more than one African American on the Louisiana Supreme Court. The African Americans who have been on the Louisiana Supreme Court got there because of demonstration, as a result of litigation. For power yields nothing without a demand. Dr. Martin Luther King said that progress never rolls in on the wheels of inevitability, but it comes through struggle. It was the struggle that resulted in the Chisholm lawsuit, that resulted in Revius Artigue being the first African-American justice of the Louisiana Supreme Court. He was followed by Justice and then Chief Justice Burnett Johnson, who was the second African-American to serve on the Louisiana Supreme Court. And now we have Justice Piper Griffin, who serves on the Louisiana Supreme Court as the third member. After 211 years, I will be the fourth member, and the only one elected outside of the parish of Orleans. That's progress for our state. It's progress because our state, in the absence of this, would have forfeited the contributions of life experiences, the contributions of diversity and educational background, the contributions of different perspectives and different outlooks, the ability to take the facts and to put them in context as we deliberate the law and make the administrative decisions for the judiciary of our state. The more women and the more minorities that you have on the court, the more gifts that are brought to bear, the more perspectives, the more life experiences, the more diversity of talents and gifts that will help people feel more like they are being represented. So we started out in this litigation process about the time when I, as a 30-year-old, at the tender age of 30 years old, when I entered the Louisiana legislature. And I can remember vividly at the governor's mansion when Governor Edwards was meeting with the Legislative Black Caucus, the conversations we had to persuade him to get on the phone to the Attorney General and to the Secretary of State and to have them join in the consent decree and the Clark matter. Janice Clark had the temerity and the courage to be the lead plaintiff in the Clark versus Romer and Clark versus Edwards lawsuit. It resulted in us now having 101, and unfortunately, we just lost one of our good ones, Jules Edwards of Lafayette, who was a beacon light of hope in our state judiciary. He is recently deceased. But now there are 100 African-American judges in the state of Louisiana out of 363. And so as a result of the Clark litigation, we became more representative of the third of the population in this state. And it also resulted in the fact that we now have the highest per capita number of African-American judges than any state in the United States. After the Clark lawsuit, as a member of the state Senate, I filed the legislation to create the 2 minority seats on the Baton Rouge City Court because the Clark litigation did not address the city courts. And then there was Chisholm, the lawsuit that provided for the election of African-American justices to the Louisiana Supreme Court. It's been an ongoing battle, it's been an ongoing fight, but I'm thankful that men and women of goodwill found political consensus, because while the litigation was going on in the Middle District of Louisiana, while we were expending millions of taxpayers' dollars resisting the creation of a second minority seat, we found political common ground. The governor of our state, Jeff Landry, and Liz Murrill, our Attorney General, worked with Cleo Fields, who ultimately sponsored the legislation and worked to pass the legislation, working with the Louisiana Legislative Black Caucus and other members of the legislature. We have one of our fine representatives, Representative Freiberg, here today, working to find political consensus, working to do what was morally compelling, to do what was fiscally responsible and not continue to spend millions of dollars fighting what was a civil rights issue, which was an issue that said that a third of the population of this state ought to have representation on the Louisiana Supreme Court. Working together in the legislature, we were able to find compromise. And then there was, as a result of the legislation, it was a difficult fight. The bill failed in both special sessions of the Louisiana legislature. And finally, in the regular session, when Senator Fields authored the legislation and shepherded through the process, finally in the regular session, we got a bill passed that created this second majority-minority seat, the seat which I will take in January. And as a result of that, the litigation in the Middle District was able to be settled, and millions of dollars of taxpayers' money was saved as a result of that process. And so that is where we are today. We're now going to have 2 of the 7 seats of the Louisiana Supreme Court that's going to be represented by African Americans. Why is it important that we have women and we have African Americans and other minorities in the judiciary? Why is it important that they have a seat at the table and be a part of the deliberations? It is because you need diversity of thought. When we are deliberating these cases, you need different perspectives. You need people who, by virtue of their life experiences, can put into context the actual facts that are part of the case. You need individuals there when people walk in, they can feel like these individuals have sat where I have sat. These individuals are individuals that might understand my plight. Now, ultimately, at the end of the day, we make ourselves self-aware of our implicit biases, our prejudices, and anything that might cloud our judgment. And that's why we wear the robes in the first place, to let us know that it's not about us, but it is about the law. And though we set those things aside, the contributions that are made to the discussions and the better context in which the cases are understood are helped by the diversity. As a member of the Louisiana legislature, I think I can bring something to the court. I was a member of the House and a member of the Senate And so I understand how the law is made and have a great deal of respect for the fact that judges are not lawmakers, that the final expression of legislative will is the law, and that is vested in the legislature. And so when I left the legislature and became a judge, I recognized the fact that it's not my job as a judge to be a super legislator. My job is to interpret the law as written by the legislature and make sure that it comports with constitutional law, to make sure that even the legislature doesn't exceed the boundaries that have been established by the Constitution. That diversity of life experience will help me as a justice of the Louisiana Supreme Court. The fact that I have taught for 35 years as an adjunct professor at the Southern University Law School and then 25 years in the Nelson Mandela School of Public Policy teaching pre-law classes, it allows me to understand what is going on in the academy, because not only does the Supreme Court decide cases, but they decide discipline and they regulate the practice of law. They are in constant contact and interaction with the law school. I understand what is being taught in the academy, and I understand the role that they play. And so that will, again, be something that I will bring to the table. I will bring to the table also my own life experiences. As a poor boy from the bottoms of South Baton Rouge, raised most of my life by a single mother who went to work every day, who made sure that I went to church and made sure that I got an education. And so I understand some of the underlying problems that we have that lead to crime and other things, because I have experienced poverty. I have been in the shadows of life. And so those life experiences I will bring with me to the Louisiana Supreme Court. To not allow for diversity in the judiciary would divest us of the opportunity to have people of different backgrounds and different life experiences to have a seat at the table and to have input in the various decisions that are going to be made. I look forward to serving on the Louisiana Supreme Court. My judicial philosophy is simple: to simply apply the law to the facts that are given. To do so without fear or favor. To do so setting aside my own desires for political outcomes, recognizing and setting aside my own biases and prejudices, but contributing what I bring to the table to the adjudicative and administrative functions of the court. I think that's good for the judiciary. I think that, again, it is certainly a civil rights issue. Although one man, one vote does not apply to the judiciary, every consent decree that we've had in the state has looked to that issue of whether or not individuals have a meaningful opportunity to elect a person of their choice to the judiciary of our state. Some of the things that I'm going to focus on as the newly elected Justice of the Supreme Court is going to be domestic violence. I currently serve as a part of the LPOR faculty of the Supreme Court, teaching lawyers and judges and other community partners about this issue of domestic violence, and more importantly, training judges how to handle domestic violence cases. We have a pilot domestic violence court in the 19 JDC. We need to make that court permanent, and we need to make sure that we expand domestic violence courts throughout our state and make sure that we have a judiciary that is sensitive to and responsive to that issue, and to make sure that we interact with all of our community partners so that we can resolve this issue as best we can of domestic violence in our state. In addition to working with that, I have been recently appointed by the Louisiana Supreme Court as the chairman of the Supreme Court's Technology Commission, and I will be working in leading that commission to try to, in a very fiscally responsible way, to continue moving us in the best direction as it relates to technology in our state. We have the new challenges of AI. We have the difficulty of a situation where we don't have the type of online statewide filings and access to records that I believe would save individuals dollars and would save us tax dollars. So we're going to be looking for the best practices to make the best use of the technology dollars that we ask the legislature to invest in the judiciary, so that we can have greater access to our courts. We learned through COVID that there are new ways to do things, and many of which are dependent on technology, and we need to make sure that those technological dollars that we get from the legislature are properly dispensed throughout the judiciary. Again, we need to increase the number of specialty courts in our state. We currently have over 70 specialty courts, DWI and sobriety courts, veterans courts, family intervention courts. We have courts, again, that deal with domestic violence. We have courts in all of these specialty areas, but we need to increase the number of specialty courts in our state, particularly in our rural areas of the state, so that we can reduce recidivism. When we have these reentry specialty courts that assist us in helping individuals come back into society as productive members of society. And so we can deal with some of these underlying problems that lead to recidivism, addiction, problems with regard to domestic violence. We need to look at the fact that we have veterans in our country who have sacrificed, who have put their very lives on the line, and anything that we can do in the judiciary to move them out of the judicial system and to help them with the needs that they have, particularly when many of the issues that they have are a result of their service for our country, putting their lives on the line, then we need to do that and increase the number of veterans specialty courts that we have in our state. I will continue to serve with the Louisiana Judicial College. I'm a former chairman of the board of the Judicial College, and what that entity seeks to do is to make sure that we have a trained and educated judiciary. And that is most important, that people have confidence in that very fact, that the people that they come before are well trained and well prepared to adjudicate their life matters when they come into the judiciary. I have been fortunate to have had the greatest of cooperation, the greatest of welcoming by my future colleagues on the Supreme Court. They have bent over backwards and gone out of their way to make me welcome and to help to facilitate my transition. They will be appointing me ad hoc to the Supreme Court for December, where I will sit on the December conferences, and will also hear oral arguments on December 9th, so that it will be a smoother transition as I prepare to vote on those cases that will be heard in December, when I will vote on them in January. And so I look forward to working with my new colleagues on the Louisiana Supreme Court, who is it is a group of people who are well prepared, who are well intentioned, and who are committed to the rule of law, and I look forward to working with them going forward. At this point, I'll be glad to answer any particular questions that any of you might have, so that we don't run out of time for that. Yes, sir.
Judge, the justices in the U.S. Supreme Court, they're looking for ways to police themselves, call to order, maybe if they're out of order. The state Supreme Court, we've had a couple of judges that crossed over the line. Is there any, in your mind and anybody's mind, to tighten these restrictions or what, a little bit more?
I certainly, because of the constraints that I have under our judicial canons, will not comment, or I don't even want to seem to comment on any cases that are pending or impending in the Supreme Court with respect to current members of the judiciary and judicial discipline. But I will say that the Louisiana Supreme Court is committed to educating and training and when necessary, disciplining judges. That is part of the constitutional responsibility of the Supreme Court to regulate and to discipline both lawyers and judges, and that will be something that I will be, of course, involved in when I get to the Louisiana Supreme Court. But I can say from the point where I sit today that I have a great deal of confidence in both the commitment and the ability of our Louisiana Supreme Court to regulate correctly the judiciary of our state.
Typically, when an appellate court takes up a case that they end up disagreeing with, it's customary, if not, entirely mandatory, that they send the case back and say, here's take a look at this again with these considerations. Like, here are things that you may have gotten incorrect. In the decision that established the city of St. George, the Supreme Court essentially substituted its own decision for it rather than sending it back to a lower court level to say, take a look at this again. Is it proper for a court with a very slim, in this case, a 4-3 decision to impact a decision that, in that case, I think the case was 4.5, nearly 5 years old, and it's essentially 4 people decided that St. George ought to be created. I mean, is this something that should have gone back for further review at lower court levels?
Again, I think it would be inappropriate for me to say anything that might signal any position that I have on St. George, because the reality of it is that there are many issues that are pending and impending and percolating through the court system related to St. George that I will have to vote on as a justice of the Supreme Court, and in order to...
Let me reword it to
Okay.
make it more generic.
Okay.
How often should a Supreme Court substitute its own decision for something that has already gone through lower courts to various degrees? I mean, should it be rare? Should it be something that the court should do more often? And like I said, it's a lot of people viewed it as a curveball. How often should it happen?
I will say that generally speaking, it is ultimately in our constitutional framework, it is the Supreme Court that is ultimately the arbiter of state law matters, and to the extent that you can't raise a federal question and get up to the Louisiana Supreme Court, then certainly our Louisiana Supreme Court is the final step in the process. Now, certainly the Supreme Court exercises its discretion in terms of the cases that they will hear. There is Rule 10 that has considerations, keeping in mind that the Supreme Court is not an error correcting court, but to the extent that they decide to grant certiorari, then of course, ultimately the decisions are based on a majority vote of the Supreme Court, and that is, again, that is the last step with regard to state law matters. And so it's a case-by-case analysis, and ultimately the justices of the Supreme Court do their best to reach decisions that are in comportment with the Constitution and laws of this state, and they have been charged with making those final decisions by our state constitution. And so I don't think it's a percentage game that there's a certain number you should or a certain number you shouldn't. It's a case-by-case analysis, and I believe that the justices of our Supreme Court are very hardworking, and they are very committed to the rule of law, and they make the best decisions that they can based on what they have in front of them, and they are constitutionally the final arbiters of those matters.
Can I ask what you thought of it? Did it leave you scratching your head?
Again, because I will be voting as a member of the Supreme Court on matters impacting St. George, I will have no comment as to past or future issues regarding that.
More than half of the murders that happen in our city have been proven to be domestic violence issues.
Yes, ma'am.
So I'm pleased to hear that you want to focus on that. I wondered, when you talked about educating the judges, how would that happen? What is the...
Well, currently, LPOR, which is Louisiana Protective Order Registry, they have a federal grant. They are an entity within the Supreme Court. They have a federal grant to go out and educate the judiciary. They have a faculty of judges, I'm a member of that faculty, and what we do is that we go out and we put on continuing legal education seminars for judges. Sometimes it's during the fall conference or the spring conference, and we bring them in to talk to them about best practices for handling domestic violence cases. We encourage them to be aware of the lethality indicators such as strangling. To be aware of the opportunities they have, such as the removal of weapons, of having Gwen's hearings, of making sure that when people come before the court that they're taken seriously, because this is a very serious matter. So again, what we do is we go and train judges along those lines, and we also put on educational trainings for other partners in the community, district attorneys, law enforcement, public defenders, and others, the social workers who come together with us to make sure that we're all on the same page in terms of what are the best practices. We also go, of course, and make ourselves available for informational purposes at the legislature to testify on legislation affecting domestic violence. And I understand from Justice Crane that there is a strong push now at the Supreme Court to do more in the area of domestic violence, and I look forward to lending my voice to that effort. Another thing that should be a consideration is whether or not we require some mandatory hours of judges for domestic violence training. The training they get now is provided, but it's on a voluntary basis. But I think that that is something that we should strongly take a look at, the requirement of judges to have a certain number of hours in domestic violence. And again, there are things like domestic violence, implicit bias. There are a whole lot of areas in which we can offer training and education to our judiciary beyond the substantive and procedural law that we train them on. But domestic violence ought to be at the top of the list. There are too many deaths, too many tragic instances that could have been avoided. And one of the things that we do in that training is the thing that's called comings and goings. And what comings and goings does, you start out, all of the judges, everybody in the room, they get a certain number of money, and they get a certain number of times they could stay at a relative's house, certain number of vouchers for hotels, and they have a certain amount of cash, and then we blow the whistle and they have to move and they have to give some of that up. And ultimately what it does, it shows that at some point you run out of money, you run out of family, you run out of friends, you run out of public assistance, and you run out of having a shelter for your kids, or the shelter doesn't take kids, you've been living in your car, and at some point, unfortunately, individuals go back. And the purpose of that is to try to say to judges and to say to others in the community when they ask the question, well, why do they go back? Why do they drop the charges? Sometimes it's economic. And so that is an example of the kind of training that we do with them to try to answer some of the questions that people have, like why do they go back? Yes, sir.
The Supreme Court judges and the other judges in Louisiana have an ethics code.
Yes, sir.
Such that you have to declare all the gifts you receive.
Yes, sir. Yes, sir. Annually, there are 3 reports we have to do. We have to do an annual financial disclosure report that lists in categories income, sources of income, property, investments. We have to certify under oath that we filed our taxes, both state and federal, that we have sought an exemption. That's the annual report. Then we also do one that deals with quasi-judicial things that we do, such as teaching. I teach at the law school, so I disclose that I teach at the law school, or that or this particular organization asked me to come and to give a continuing legal education speech. And then we have the third report, which is the gift report. And so within certain dollar amounts, you have to report any gifts that you've received in that year. And so the Supreme Court has in place these annual reports to provide for transparency, to provide for accountability, and so that the public can access that information and to be persuaded that the decisions that judges make are not being influenced by some outside source. Yes, sir.
Can you comment on the U.S. Supreme Court taking up the new redistricting case involving Louisiana on that?
Again, unfortunately, because of our canons of judicial conduct, we are prohibited from making any comments with regard to cases that are pending or impending in any court, even in a federal court. And so I would not be able to give any particular comments with regard to that pending judicial case. Yes, sir.
Your record thus far, having been a legislator or well-named, book is written. Your record as a jurist at the state on your book is closed on your record as the newest member of the Supreme Court, particularly like how you got there, you know, the whole process. What would you like the biggest thing to be said about you when it's all said and done?
The same thing I would want said by my professional career is what I would want said about my personal life, that I did justly, that I loved mercy, and I walked humbly with God. With regard particularly to my professional career, that I judge my neighbors fairly. And I think that that's all we can expect of a judge. We are all human and imperfect, but I think that that ought to be what we strive to do, is to judge our neighbors fairly. Yes, ma'am.
You were talking about improving technology, the use of
Yes, ma'am.
technology. What are your thoughts about possibly live streaming the Supreme Court, state Supreme Court arguments?
Right now, what they're doing is they are live streaming the arguments, but they're not recorded for public access after they've been live streamed. And of course, it is the only court that is allowed to have cameras in the courtroom. There are ongoing discussions. I'm not sure, because I'm not yet within the conference of the Supreme Court, but I know in the greater legal community about, asking the Supreme Court to take a look at whether or not that would be more expanded in terms of actually, for example, the Supreme Court having, their recordings ultimately made public, or having cameras in other lower level courts, either the courts of appeal or the trial level courts. So that is certainly would have to be as a result of rulemaking by the Supreme Court. But they have made a big step, and that is live streaming, videos live streaming their oral arguments as they occur. The U.S. Supreme Court, all you get is the audio, and you don't get the video. So we're ahead of the U.S. Supreme Court, is that at least our live stream is video as well as audio.
To my knowledge, the Supreme Court does not currently have an information office like many state agencies, and I know that they have considered having one, but
they do now have. They do now have one. It's a pretty robust office. One of the things that I found that a lot of the questions I have, for example, when I was preparing for this, I called the director of the public relations. Give me some information on what we're doing on specialty courts. I did a speech on Friday. I was the banquet speaker for the Louisiana Law Institute, and I called the Supreme Court's library, and they had a wealth of information. So they, in terms of what is made available to the public through the Supreme Court's library, and what's made available to their public information department, and what they have on the website, a great deal of information is both on their website and in their annual report. So the Supreme Court has made a lot of progress in terms of transparency, and even the posting of these annual reports that we talked about. Those are made available. Any citizen can go and see what kind of money their judge or their spouse makes, and what kind of gifts they've got. So there has been a push toward greater transparency being led by our state Supreme Court, and I'm glad to join an organization that's concerned about transparency. Yes, sir.
Without commenting on any particular cases, what types of issues or cases do you look forward to hearing?
Of course, it'll be a change, because where I'm at, we are an error-correcting court, and you get to my court by way of appeal. You have a right of appeal. The only cases that bypass my court are cases where the death penalty has been imposed, or where the trial judge declares a law unconstitutional. Otherwise, I get everything. And of course, once it leaves my court, there is Rule 10 of the Supreme Court, where they look at certain factors to determine the types of cases that they hear. So the types of cases generally that make it to our court is where there has been a dispute within the circuits. First Circuit says one thing, Second Circuit says something else, and the Supreme Court will find the right case, because bad facts make bad law, but they will find the right case in order, in many instances, to resolve the differences within the circuit, and issues where it's clear that the trial court or the lower courts have abused their power. The Supreme Court is more likely to take on those cases where there's been a res nova issue that has been decided by a lower court, an issue of first impression that had never been decided by a court in our state and certainly had not been looked at by the Supreme Court. That is something that's more likely to be heard by our court. And so the difference that I will find is that I will not be hearing every case in which error is alleged, but through the discretionary writ of certiorari, the Supreme Court will be deciding which cases that they will take up. The idea in our system is that you have a right of appeal, and that right of appeal is satisfied at least in one instance at the intermediate appellate court level. And so whether or not you get a second opportunity for review by the highest court, the Supreme Court, is discretionary on the part of their court, realizing that the number of cases that come through the intermediate appellate court, certainly it would not be possible for the Supreme Court to hear all of those cases, and so they have to be, make sure that they are using the best time they can to deal with the most important and pressing matters of legal consideration in the state. So that would be a transition that I will have. Yes, sir.
For information purposes only, aren't there some very important issues that come before the legislature, for the judiciary, in the regular session? Are you aware of anything?
Well, certainly, whenever the legislature's in town, there's a possible court case on the way, and so they're going to be in a special session. And I say that as a former member of the House and the Senate. Certainly, ultimately, we get to, as the Supreme Court, through the power of judicial review, to determine the constitutionality of what comes out of the legislature. So every time the legislature is in session, there's a possibility that some law that they pass, although presumed constitutional until determined by the courts to be otherwise, certainly are subject to judicial review. And so the more controversial the issues that come before the legislature, the more possibility that they will end up before the courts. And of course, again, the courts recognize that it is not our job to legislate, but it is our job to make sure what the legislature does comports with the Constitution of the United States and of our state, and we take that role seriously.
Are people or lawyers using the appeal more and more over the last few years to increase the load on the courts?
Actually, it's been just the opposite. I think a part of it is it's mediation. A part of it is the cost of litigation to actually file and to prosecute matters within the court system. So really, and of course, we don't have the necessary empirical data, because the data we have is pretty much skewed by the pandemic and other things. But right now, the Supreme Court has engaged the National Center for State Courts to embark upon a time study to let us figure out, exactly what is coming in and how long it's taking to address and how many people you need to address it, and to basically then have the empirical data that can flow through the Louisiana Supreme Court's Judicial Council to the legislature, so that the legislature can make any policy decisions that are necessary with regard to the change in the judicial workload, for example, that has resulted over the past several years. But in order, you need to be data informed, and these decisions that are going to be made by the political branches of the government need to have the necessary data, and that's what this time study, which will involve district court judges and courts of appeal judges, in order to be able to identify, again, what's coming in, how long it takes, how many judges, how many law clerks you need to get it out, and then once that information is passed on to the legislature, they'll make the policy decisions. Yes, ma'am.
You talked earlier, you used the analogy, I think it was of a sword in the road, something like that.
Mhm.
Is there any way we can get to the point where we take politics and political leanings out of the selection of judges?
Well, again, and I think I can say this. I think politics will always, in this democratic process, it just depends on who's involved in the politics. And the electoral process, it is the citizenry who are directly electing their judges, and that's the politics that are involved. But when you have the selection process, there's politics there because somebody is selecting the selector. So if it's the governor, if it's the president, if it is some merit committee appointed by the governor at the state level, or in the case of the federal judiciary, where you have the politics of presidential elections, the politics of senatorial elections for purposes of confirmation, it's still politics. So whether you have an appointed judiciary or an elected judiciary, you're going to still have politics. The question then becomes is whether or not the politics is going to be direct through the electoral process, or is it going to be indirect through the president, the Senate, the governor, and some commission or some entity appointed by the governor or influenced by the governor. But I don't think you're going to be able to take, and I'm not sure you really want to take the people's right to weigh in, whether it's through their vote or through their elected officials, weigh in on who sits in the judiciary. I think that, the judiciary has to be free and independent. And again, you have lifetime tenure to try to help that at the federal level. You have term limits after age 70, and that can be debated. As I get closer to age 70, I'd like to debate it. But there are, it's not as if, somebody can, and then of course, even within the powers of the Supreme Court, they have power with regard to who stays, and so there are safeguards that are built into the respective systems. But I think ultimately it is important that the citizenry have some input in who's elected. It's just who are you going to contribute to the president and the members of the United States Senate? So you're not going to ever take money out, or whether you're going to contribute to a state judge's campaign committee. You're never going to take the money out. You're never going to take the politics out, because who's ever making the appointments and doing the confirmation, they're elected. And so, we have different states who do it different ways, but I've heard complaints on both sides. Yes.
One more question. You can ask one more.
I was just going to say, because I know you've read things like the expose de notices and stuff like that, I know you understand the civilian tradition of Louisiana, which was here way before, the common law approach. Would you think, that we might not have some of these problems if, we just remember that?
Well, actually, we're going to try to help everybody remember. Next year, we will celebrate the bicentennial of the 1825 Louisiana Civil Code, and the Louisiana Supreme Court has taken a lead in trying to make sure the citizenry of our state recognize our rich civil tradition. And so, again, the Supreme Court is going to be helping to educate and remind citizens of our state and of the world of the unique civil tradition that we have in our state through the bicentennial of the 1825 Civil Code.
Is it okay? I just want to know, are you where you want to be in life?
I am thankful for God's grace that has placed me where I am. And should it be His will to do something else, then I will always want to be in His will. But as I would say in my church, if God doesn't do anything else for me, He has done enough. I am blessed.
Before you get away, I'll let you know how much I love you. You're amazing. You always get advice out from that.
I appreciate it.
We just got Hope Southern